We're going to turn it over to Don Vanarelli now. Don has his own law practice in, I think, Westfield, right?
Right.
And Don actually was the attorney on the Supreme Court case, the New Jersey Supreme Court case in Ray Carey, that sets forth the standard that most people follow if a guardian needs to do gifts for Medicaid planning, if you're seeking authority to do gifts for Medicaid planning. So without further ado, I'm going to turn it over to Don.
Okay, so how was that? You see that screen?
Yeah, we see it.
Yeah, okay, very good. All right, Constantina was great in terms of presenting everything that you need to do with the regular guardianships. I'm going to talk about Medicaid planning in the context of the guardianships. Let's see. Here we go. Okay, so we're trying to, basically what we're trying to do is you have usually an incapacitated, often a parent or a spouse, and we're trying to, they're becoming less independent, and everyone can see that, and we're trying to accelerate their eligibility for Medicaid. That is so many of the people that are our clients. They're interested in, they don't want to hurt anyone. They want to make sure that their loved one gets the care that they need, but they also want to see if they can protect their assets for themselves and for their loved ones. So now we're able to do that. We are actually able to engage in Medicaid planning, even though someone's incapacitated. And Kerry was decided in 2004. Prior to that, it was all over the map about whether you were able to do this or not. You could present a will. You could present statements that the person made from loved ones about what they wanted to do with their assets. And a lot of the judges would just deny it, saying it was a fraud on the public. But we do have that right now. So what do? A client comes to you and presents this problem that they have. They want to make sure that the person gets the care that they need. They want to preserve assets for their children if possible. First thing you do is look to see if someone has a power of attorney. If they do, you may be able to obviate the need for the guardianship completely. Could be a durable power of attorney, could be a springing power of attorney. It's sort of irrelevant. The important thing is, does it permit gifting by the agent? And a lot, even today, so many years later, a lot of the powers of attorney that are drafted up by you, me, our colleagues, don't contain gifting authority. And without a gifting, it has to be an express right to make gifts. You can't just say, my agent can do everything that I can do. If I was capable of acting or if I was competent. You need an express section permitting gifting. And if you have that, you don't need a guardianship. Simple as that. And if you don't, and like a lot don't, you're going to have to suggest the guardianship and do what I'm going to outline. Okay, so you looked at the power of attorney, you looked at the wills, you looked at all the estate documents, trusts, whatever they have. You don't have the authority to make gifts, and the loved one, the incapacitated person, is incapacitated and not able to sign any legal documents anymore. So they're not going to be able to voluntarily give the power to make gifts to anyone. So you have to go to court. And you have to include the request for Medicaid planning in the guardianship application. So you have to show that, you're still the guardian and you're still a fiduciary, and you have to show that the proposed Medicaid plan is going to be in the ward's best interest. So I thought I'd start by talking about the guardianship statute, then the case law framework. And the paper that I put together for this is on page 1 of your handbook, and page 17 are all these slides, so you can follow along and make notes if you want. So the guardianship statutes give the court the right to exercise all powers. The court doesn't have a right to give to make a new will for the incapacitated person, but they can do just about anything else, and they can confer those rights upon the guardian. So 3B: 12, 49, 50, and 58. The rights that the court has includes the right to make gifts, engage in planning, utilizing public assistance programs. This is relatively new since Curry came out, and really the court is supposed to look at the whatever existing estate documents that the incapacitated person may have to see, who that when the person was competent, who they wanted to, who they identified as people who they wanted to receive their assets, because that's going to make a big difference on whether your plan is going to be approved or not.